Harris County, Texas, defendant Byron Laws appeared in the courtroom of Judge David Fleischer on March 20th, 2025. Mr. Laws had been charged with driving while intoxicated with a blood alcohol concentration greater than 0.15, stemming from an incident on October 5th, 2021. Nearly 4 years later, the case was still pending. At this hearing, Mr. Laws was represented by recently appointed defense counsel Anna Eady. After reviewing the file, Ms. Eady asked Judge Fleischer to revisit the issue of probable cause for the original arrest. The United States Supreme Court addressed this issue in Gerstein v. Pugh in 1975, holding that the Fourth Amendment entitles a person arrested without a warrant and charged by a prosecutor without grand jury involvement to a timely judicial determination of probable cause. The court made clear that a prosecutor's decision to file charges is not enough. Probable cause must be determined by a neutral and attached magistrate. Texas law incorporates this requirement in Article 14.06 of the Code of Criminal Procedure, which provides that a person arrested without a warrant must be taken before a magistrate without unnecessary delay and no later than 48 hours after arrest. In this case, that probable cause determination would have taken place in 2021, shortly after the arrest. Now, however, Ms. Eady is asking Judge Fleischer to take another look at whether probable cause existed at the time of the arrest.
I'm approaching on Laws.
Okay.
Is the last name. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
All right.
You don't think there's PC?
Laws.
No.
Yes.
You don't think there's PC?
I don't, looking at the DIMS, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case and I just got appointed on it last month. So.
Did you already approach on PC on this?
I have not.
Don't worry about it.
I'll just be honest, Judge. I had assumed because of the age of the case that PC had been done. But.
Of course it has been.
Right.
But there's new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through it. 2021 case. Thanks, sir. Look. All right. On October 5th, 2021, the officers were dispatched to a DWI call. Excuse me. I see the issue. Okay. Officers were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes while making a U-turn on the highway. Heavy traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, odor of alcoholic beverage, and poor balance, and a order full quiet, please. Cold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the HEN, a 7 out of 8 on the walking turn, and a 4 on leg stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address, and there's no reason given in the DIMS for the stop.
She read something different.
That was not in the DIMS.
That seems to be from the offense report.
Sure, but I mean, what's...
But I thought for PC, we just used the DIMS because that was sworn to, and not getting into the.
Show me where it says that. I don't know of any rule that says that it's PC has to be done on just the DIMS.
Okay.
You know, I don't. If you can direct me to something,
Okay,
but I've
and
never.
that just may be my misunderstanding of a
Yeah,
policy.
I don't. And I've heard this before.
Okay.
Right, but I can't. I've never seen anything where someone has ever directed me to saying, "Hey, PC is only has to be just on the DIMS." You
because
know?
the DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into
That's a sworn document too.
the offense report's on a sworn document.
I mean, I guess, Your Honor, my thing is it's a public record that they're using the DIMS taking the offense report. And also, I have never seen it where we have to rely solely on the DIMS for probable cause. It's probable cause. In fact, when we go to the grand jury, that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence. And that's probable cause.
Yeah, I don't know. I don't think that. I mean, let's look because I don't know. You know.
Okay. I'll stand
And
down.
I'll
Go check with
sure.
Ms. Rogers.
Ms. Eady argues that a probable cause determination must be based solely on the sworn allegations contained in the DIMS report, not the allegations found in the offense report. DIMS stands for the District Attorney Intake Management System. It's the electronic platform used when police officers submit charges to the district attorney's office. When an officer makes a warrantless arrest, they contact a prosecutor for authorization. If the prosecutor approves the charge, the officer completes a series of required electronic entries in DIMS, including identifying information about the defendant, the alleged offense, and a summary of the underlying facts. According to the DIMS manual, that summary must contain a concise factual narrative explaining who committed the offense, what occurred, when and where it happened, and how it unfolded. The DA's office uses this summary to show probable cause for the warrantless arrest, and the manual further specifies that simply referring to an arrest or offense report is not sufficient. The officer must expressly set out the essential facts. Moreover, once the DIMS submission is transmitted to the district attorney's office, it cannot be modified. The record is locked. In addition, under reforms implemented in Harris County, officers must affirm under penalty of perjury that the facts entered into DIMS are true and correct based on their knowledge and belief. An offense report, by contrast, is the more detailed investigative narrative prepared by the officer. But unlike the DIMS entry, it is not the sworn probable cause submission reviewed at the time of a warrantless arrest. Here, Ms. Eady argues that only the sworn DIMS entry may be considered in determining probable cause, and in Mr. Laws' case, she contends that the DIMS summary failed to articulate the basis for the traffic stop, rendering the probable cause determination legally deficient.
So you're saying that the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement, and speaking with Ms. Rogers, we're looking, but it's not,
And I'm looking to.
okay.
I am too.
There was a class action lawsuit, and as part of the settlement, the agreement was that Harris County would use the DIMS to support
Okay,
PC, but we're getting that all together.
me too.
Okay.
Was there a result for that?
Yes.
Or is it in action now?
No,
No, this was some time ago. So this was before the DIMS summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Court. And out of that lawsuit, it was just allegations of Fourth Amendment violations, because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation. So I think it is a Fourth Amendment issue.
I'm curious, I'm curious, for PC purposes, can state use an offense report to supplement a DIMS? Or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
Well, the four corners of the DIMS is what's sworn to. The offense report is not.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the offense report, he is committing a crime. So, I mean, I don't say that the offense report is not sworn to. It's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false
Right, but perjury's
an official document?
a different crime.
No, but it would also under the purview of filing a false,
Well, Judge, if an officer came into court and was asking for you to sign a search warrant and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone sworn to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest. It was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
Was there blood in this case? Right. Okay, give me 5 minutes.
Okay.
Huh? Okay.
If it's okay with you, we'll take
Can
a
you
look.
show them?
Yeah, that's fine.
Ms. Eady and her colleague point to a class action lawsuit over how probable cause determinations were being handled in Harris County. The case they're referring to is Lomas versus Harris County, filed on December 28, 2016, by attorneys with the Civil Rights Corps and the Texas Fair Defense Project. The lawsuit alleged that Harris County was violating the Fourth Amendment by continuing to detain people after warrantless arrests without a probable cause determination by a neutral magistrate based on facts supported by an oath or affirmation. At the time, the DIMS probable cause submission used for these determinations was not sworn. On November 1, 2017, the case was resolved through a settlement agreement. Harris County did not admit any Fourth Amendment violation, but the district attorney agreed to change how probable cause statements were presented for warrantless arrests. Under the settlement, the officers would be required to swear to the facts as they entered them into DIMS. According to the settlement agreement, the system was modified so that when an arresting officer entered the facts of an arrest into DIMS, the officer had to affirm, under penalty of perjury, that the information provided was true and correct based on information and belief. In other words, the agreement pushed Harris County toward relying on sworn DIMS submissions rather than unsworn summaries when establishing probable cause for a warrantless arrest.
Mr. Laws, come up. We have court orders for a reason. And when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
We were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to. I want to stick with the agreement that the county came to with the district attorney's office,
So, I'm not saying it's this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because shit, you might get like 15 supplements.
And here's my question for the board, and I'm not saying we're doing this in this case, I'm just saying for cases going forward. To me then, does that then behoove, does that say we can't take it to grand jury?
You can, of course you can.
So,
Yeah.
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them.
Yeah,
As far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
Yeah, I'm just, and this is for my own.
And you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you, Judge.
Oh, really?
So we wouldn't be held to that same standard.
You need to do what you think is right.
Okay.
Like I'm going to do it, and like she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. Not everybody is.
I understand.
Which is good.
Thank you.
God love you.
Judge Fleischer ultimately concluded that the sworn facts contained within the DIMS report were insufficient to establish probable cause under the framework adopted after Lomas versus Harris County. However, Mr. Laws had been charged by an information, which is a charging instrument filed by a district attorney, rather than by a grand jury indictment. Therefore, Judge Fleischer made clear that his ruling did not prevent the state from pursuing the matter through a grand jury if it chose to do so. A grand jury is a panel of citizens tasked with determining whether there's sufficient evidence to formally charge a person with a crime. In Texas, grand juries consist of 12 members governed by Chapter 20A of the Texas Code of Criminal Procedure. and at least 9 must agree that probable cause exists in order to return what's called a true bill, which becomes a formal indictment. If fewer than 9 agree, the result is a no bill and the case does not proceed. Here, although Judge Fleischer found no probable cause based on the sworn dim submission, he emphasized that nothing prevented the state from seeking an indictment through that separate constitutional process. After the ruling, the prosecution moved to dismiss the charge against Mr. Laws while reserving the right to refile. The court granted the motion, and the case was formally dismissed. As of this recording, Harris County has not refiled the charge against Mr. Laws. This case underscores why procedural precision matters in the criminal justice system. When officers draft probable cause statements and prosecutors approve charges, they're serving as constitutional gatekeepers. The Fourth Amendment demands that criminal accusations be supported by sworn facts and reviewed by a neutral magistrate before a person's liberty is restricted. Those requirements are not empty formalities. They are deliberate safeguards designed to prevent unlawful detention and to ensure that every prosecution begins on a lawful and reliable foundation. By insisting on sworn factual support and independent judicial review, courts protect both the rights of the accused and the credibility of the system itself. If you found this breakdown helpful, consider subscribing and sharing. And if there's a case you'd like us to cover, let us know in the comments.